I mean, I do believe that a big reason Alex Murdaugh got convicted is because he's a narcissistic cockroach. But if you take out the financial crimes and you focus solely on the evidence that connects him to the murders, and you look at motive, opportunity, physical evidence, I mean, it's thin.
Yeah.
I mean, most people think he did it because he's Alex Murdaugh. What's good, people? I'm attorney John Mobley. I have prosecuted and litigated complex civil and criminal cases for over 30 years, and I'm still actively litigating these cases today. My experience was forged in the legal trenches, going toe-to-toe with some of the best lawyers in the country, and I'm still actively litigating these cases. On this podcast, I'll be giving no-holds-barred, hard-hitting legal analysis on the legal issues that are gripping the nation. But you want to hear more than just legalese or legal mumbo-jumbo. It's important to have the perspective of a non-lawyer. So my assistant Kayla is joining me in the podcast, and she's going to ask me the tough questions for which you want the answers. So please join me on Legal Deep Dives and listen to me call it like I see it. Now, when we last left off, I was giving my thoughts, my opinions, my perspectives on the Alex Murdaugh trial, and I was in the zone. I was hitting on all cylinders. I was rolling. Hey, I was cracking myself up. And then what you didn't see, what happened off camera, is this. Basically, my production team, my assistant Kayla, they all decided that I was going on a little bit too long. So they had a brief discussion with me with tape, and we decided we were going to make this podcast a two-parter. So now we're going to pick up where we left off and take up with part two.
And after following the trial for so long, is there anything you would have done differently? Is there anything you think that they missed that would have been key, major in the trial?
I would have done a lot of things differently. I mean, you talking about calling it like I see it. Whew, this is a call it like I see it book. You know, I think, you know, like with the prosecutors, and I will say this, and I've said this before, you know, it's always a little bit difficult, you know, when you're critiquing or Monday morning quarterbacking, like I like to say, the trial performance of colleagues. Mm-hmm. You know, when I cover cases that are here in this state, I know all the lawyers. You know, I mean, sometimes I've tried cases against them. I've smoked cigars with them. I played golf with them. I've worked for some of them a long time ago. I have a lot of respect for them. But like you said, I got to call it like I see it. I think the prosecutors weighed too heavily on the financial crimes.
Okay.
And I think that's because, you know, they really didn't have that strong of a case. I mean, I do believe that a big reason Alex Murdaugh got convicted is because he's a narcissistic cockroach. But if you take out the financial crimes and you focus solely on the evidence that connects him to the murders, and you look at motive, opportunity, physical evidence, I mean, it's thin.
Yeah.
I mean, most people think he did it because he's Alex Murdaugh. Okay.
But I mean, he lied and said he wasn't there, but there was a video where you could hear his voice and they found out he was there. I mean, there was just so many things.
Well, here's the whole thing about that, though. Okay. And this is where I think the defense made a mistake. Mm-hmm. You know, in their opening statements, the defense said he could not have committed the murder because he has an alibi. Okay. And, you know, even before his voice was played on that Snapchat, I mean, he did not have an alibi. Okay, an alibi means a person or defendant could not have committed the murder because he was at another place at another location at the same time. Mm-hmm. So he couldn't be in two places at once. Okay, they didn't have an alibi. They had a timeline where he was only at the crime scene for a small window of time and had a limited opportunity to commit the murders. But that's not an alibi. That's just saying that's a small window of time. But again, the big problem is they got up there and said he wasn't there. Okay. which was, I just don't understand that at all. I mean, what that tells you are two things, or two or three things. One, that he lied to his lawyers even up until the day of trial. Okay, because if they're saying an opening statement that he wasn't there, that means he told them I was never there. You know, which is what he said to the police. He lied.
Because he
to the
said
police.
something like, oh, I didn't even know they were here. I went like.
And he lied to the police. And it tells you that you have a question of how much do they pay attention to all that evidence they got? Because they would have had to, the prosecutors would have had to supply them with a copy of that video prior to the trial. Okay, that's something they have to do, which means the defense had it. I mean, did you not listen to it? Did you not play it for your client? Okay, well, if you did, and if they played it for their client and he said, that's not me, okay. But I can't imagine that that happened because he conceded it was him when he testified. So I think that was a major defense blunder. I think the defense blundered by letting him get on the witness stand. I mean, you know, and I want to be clear for everybody, you know, whether defendant chooses to testify or not is his right and his decision alone. You know, so if I've got a client and I think he'd be a horrible witness because he's unreliable and has a bad record and has lied so many times, I can say, listen, client, you need to stay off the witness stand. You need to sit here in the chair and let me try to work my magic, you know, maybe use my Jedi mind tricks or something.
Yeah.
But it's the defendant's right. I cannot make him not testify. He's got the right to testify if he wants to. And oftentimes, I want to be clear, I get it on some level. You know, if you're in trouble, you know, particularly, I think more so if you're innocent, you know, if you're innocent and you're worried about being convicted for something you didn't do, I mean, you want to tell your side of it. Yeah, you want to tell your truth. You know, you're like, I got to tell them I didn't do it. You know, because you want to believe, you know, most people believe that nobody can tell their story like they can. And then most people believe that, hey, I'm telling the truth, you know, and they got to hear it from me. I get that, but that's not always the smart play. It's just not. But I believe that, I mean, there was nothing that he could have said that the jury would have believed. I mean, he was a liar. I mean, he lied constantly about everything. I mean, before the case, after the case, during the trial. I mean, so why would he think, or why would the defense think that the jury would believe anything he said, particularly when he lied about being there? And now I do think, my guess is he wanted to testify because he's that kind of narcissist that believes, you know something, I can convince him. I can talk my way out of it. That's probably what he thought. Because a lot of narcissists are like that.
It's that ego. Yeah.
Also, another thing I think the defense dropped the ball on, I believe that the defense should have been more sensitive to the fact that two people got murdered. It was almost like they were just trying to be, particularly the lead attorney, like trying to be more focused on being the center of attention and more focused on being the funnier, wittier guy, you know, or more focused on showing that he was the smartest, best lawyer in the courtroom. Because I just saw that so many times. I just saw statements that were made, conduct he engaged in that, you know, I remember thinking, man, you know, if I was on trial for murdering my wife and my child, and my lawyer is talking about my son's head being bounced on the floor like a basketball after he got shot, I would think that's kind of disrespectful to me, you know. And when he's holding the murder weapon or a shotgun, and at some point during cross-examination, the shotgun it starts pacing. Of course, it's not loaded, but it faces the prosecutor. Stop pointing, and he says, "Tempting." It's like, why are you trying to be cute? This is not the type of trial to be cute in.
Yeah.
You know, and I felt like that was something that would be very off-putting to jurors. And when jurors kind of think you're a jerk, I mean, they don't want to listen to anything you have to say. They don't want to give you the benefit of the doubt. They don't like you. You know, whenever I try a murder case, the first thing that I do is I acknowledge to the jury and the deceased family that a horrible tragedy and loss has occurred, for which they have my condolences for the loss that they suffered. And I make sure the jury hears me say that. I make sure the deceased's family hear me say that. Okay. And I also say, you know, there may be things that come out in this trial that, you know, show the deceased in a negative light. And that's not to be vindictive, and I apologize in advance, but it's necessary for me to bring these facts out in order to properly, do my job and give you the information you need to make the fair decision.
Right.
Because now, okay, I'm not a bad guy. I'm sensitive. I'm going to do my job, but I have respect for the fact that a life was lost. You got to be humble. But his lawyers, I mean, his lead defense attorney was just not at all. It was like he was trying to make the trial about himself, about showing how smart he was and how he was a big shot and he's a man. And I felt like that's something that actually did not serve his client's cause. Now, I also think from a strategic standpoint, the defense had some cards that they didn't play in this case. The first thing I would have done with the financial evidence that was admitted against him, first, I could not understand why they were trying to fight some of it. I mean, the state put up all these witnesses that testified about the financial crimes, and I'm watching these lawyers cross-examine these witnesses, and I'm thinking, why? I mean, what do you have to gain? I mean, he admitted that he stole all the money. So trying to nitpick details and dates and times and things like that was just a waste of time, and you lose the jury. And I just think anytime you stand up in front of the jury and make a statement or ask a question, it should be toward some goal. It should be toward establishing some fact that is consistent with your theory of the defense. If it's not something you can ask along those lines, just say no questions. Waste of time. But, with regard to the financial crimes evidence, I would have used what you guys have all heard me describe as legal judo, using the strength of the other side's case against them. And so I would have embraced the financial crimes. I would have embraced the fact, and I would have told the jury, something, Alex Murdaugh was a thief. He got away with stealing money from people in that town for years. People that needed that money, people that suffered horrible tragedies. And he made a lot of people upset. Mm-hmm. And I think that it's a very, legitimate, reasonable defense. And, I have this phrase I use myself. I go, okay, what can I sell? And when I say, what can I sell? It means, what is a theory of defense that people will believe is reasonable? Okay. And I think that a jury would believe that there are a lot of people that were upset with him and that probably wanted to do him some harm. Okay. I think anybody would agree with that. And that will be the people that are responsible for murdering his wife and son, and I could say even potentially they went there looking for him. He wasn't there. And they said, something, next best thing. That'll really make him pay. That's even better. I also believe that, based on the evidence, they were killed with two different long guns, and for people that don't understand guns, when I say long guns, I mean rifles, not handguns, a revolver or a 9mm type pistol. A long gun is a shotgun or rifle. And, the whole concept that one person killed two people with two separate long guns just didn't make any sense, because long guns are just bulky and hard to maneuver and carry. So the whole idea, and I would argue this is a defense, that he shot one victim with one long gun, put that long gun down, grabbed a second long gun and shot his spouse. It just doesn't make any sense to do that.
No, I agree. I don't think
you would just shoot them both with the same gun. So I don't think they really kind of played that up, that there's probably more than one other person involved, multiple people involved. And I would have also, I would have attacked the statement, or the evidence rather, that he was there on the Snapchat for a couple different reasons. Number one, everybody's making a big deal that, oh my God, see, his voice puts him there at the crime scene. Mm-hmm. Well, the crime scene was his house. So, okay, yeah, he was at his house, and but the thing is, I think it was always the prosecution's theory that, the murders happened within a very short time period, maybe a couple of minutes after his voice was heard on the Snapchat. Now, just so we're clear, I don't think that they can really establish that timeline from a medical, time of death standpoint. I don't think they can do that. Okay, they can estimate a window at time of death, but you can't come in and find two bodies that are obliterated and say time of death 2:45 p.m.
Yeah.
You can give a window, but you can't pin it down to that degree of specificity. And the whole idea from the prosecution that he was there, he committed the murders, and in that very short time period that he left, he was able to dispose of two different long guns, remove any evidence of blood on his clothing, remove any physical evidence, such that two different law enforcement agencies, the Sheriff's Department and the State Law Enforcement Division, the forensic agencies and divisions of two different law enforcement agencies could not find any physical evidence that he committed the murders. I just don't think one person, this man who's a drug addict, admitted drug addict, could, commit this crime in that fashion and in that short time period, clean up everything, get rid of everything.
And then call the cops.
And outwit, the forensic, examination teams of two different agencies. That's how people get caught. You can't there's just so much you don't take into account in a murder. That's how people get caught. And the whole idea he could do all that in a very short time period to make a telephone call and they don't find any other evidence to connect him to the murder, I just think is a stretch.
Because the rifles were still never found, right?
That's correct.
So since they were never found, how are they supposed to find other evidence against this? Obviously, there's video cameras. How hard is it without the murder weapons to come to a conclusion and find evidence?
Well, I want to answer your question two different ways.
Okay.
To answer your question directly, it's more difficult because, you typically want, well, not typically, you always want, if you can, to find physical evidence to connect the defendant to the murder. You want your best case. However, legally, you don't even need a body to convict someone of murder. And there are cases in South Carolina where a victim disappeared under suspicious circumstances, and the evidence around their disappearance, indicated that they were probably killed as a result of foul play, and they made an arrest, and people have been convicted. So from a legal technical standpoint, you don't need physical evidence. You can make a conviction based on circumstantial evidence if it's strong enough. You don't even need a body. But in a case like this, I just think that this graphic and this bloody with two different people are looking for physical evidence. And, now, of course, they were able to determine that one of the weapons, at least one of the weapons, was consistent with the same type of weapon that he owned. But, he was a hunter. It was a hunting property. So, he had a lot of different weapons. Different types of rifles. And there are other people in that community, if it's a hunting community, that are probably having similar rifles.
Right.
So to try to, but they couldn't say definitively that it was his rifle or a rifle that he owned. And I think there was also some evidence that one of his sons often used that rifle and had lost it. So, it was a very defendable case. The only real evidence that he committed the murders, the only real evidence that connected him to the murders was his voice on the Snapchat and him lying about being there. But if you take that out, everything else out, this case could have easily been, resulted in a not guilty verdict. And I truly think that when I look at how this case, the result of this case from the standpoint of the conviction and the reversal, I don't think either side won. I think the defense lost the case and the prosecutors lost the case. I think they both lost the case, quite frankly.
Yeah. And then, so just to kind of clarify on some speculation that's going around, just to get some sort of idea, a lot of people are bringing up the boat crash from 2019. I think it was his housekeeper, or maybe, that also died, and they were trying to tie him to that. Do you think that had any cause on the trial as well? Do you think that they were trying to tie in those speculations around those two deaths into the murder of his wife and son?
Well, you are correct from a historical standpoint. There were a number of suspicious deaths that were associated with Alex Murdaugh. I think there were 3, as a matter of fact. There, the housekeeper falling down the stairs. There was the kid that was found in the street, or a youth that was found dead in the street. That that I think the Murdaugh family was alleging, or local law enforcement was saying, oh, it was a hit and run, but there's other evidence or other statements that these injuries were not consistent with being hit by a car. That part of the whole Murdaugh Crooked family, they got law enforcement to kind of do their bidding. And there's a case where a young girl died in a boating accident involving one of his sons, and allegations of special treatment. I mean, from what I recall reading about that, like when the girl died, I mean, they wouldn't even let her parents go to the crime scene, but they let Alex Murdaugh go to the crime scene.
Yeah.
And all that. So there's a history of people dying around Alex Murdaugh. However, none of that, no evidence or information about those was ever a part of the trial. Now, do people probably know about that stuff without publicity? Yeah. And again, I think he was convicted because he was Alex Murdaugh. I think if that was Joe Blow and there was no history of prior bad act evidence, and there were no financial crimes, that would have probably been a not guilty verdict.
Yeah. And what are your final thoughts on the case? Is there anything you want to talk about that you were shocked by? Anything that you feel like we didn't go over that everyone needs to know? Or just something that you think is just absolutely ridiculous?
Well, Kayla, as always, I got to call it like I see it. I think this case was mishandled by both sides. I think the prosecutors really made a mistake in trying to put in so much financial evidence, the financial crimes. I think the defense really should have been a little more dialed in regarding their defense in this case. And I think that in the retrial, I'm certain the prosecutors aren't going to completely give up on financial evidence. I'm certain they're going to try to get some in. I do believe at this point, though, no matter what happens, he is going to get convicted. I mean, I just don't see any scenario where any jury in this country would find Alex Murdaugh not guilty, because he truly is a narcissistic psychopath cockroach. Anyway, that's all I got. You may agree with me, you may not agree with me. Either way, do me a favor, post your comments, post your questions, and call it like you see it. That's it.